Hey, welcome back to another session of Kelly's Take Two pre-licensing Zoom review. It's great to have you back. We left off the other day talking about the North Carolina Standard Offer to Purchase Form 2T, which is the sales contract created between in partnership with the North Carolina Association of Realtors and the North Carolina Bar Association. And I do believe we left off getting ready to dive into page 6. So let me go ahead and get my sharing set up for you, and we will go ahead and take this on. All right, fantastic. Like I mentioned earlier when we met before, there are parts of the standard form that I'm going to slow down and spend a decent amount of time on, and other parts of Form 2T that I'm going to hit very lightly for testing purposes, shall we say. Do know that when you take post-licensing, we will be going through this form again, line by line by line. And when you join a firm, should you choose to do so, your broker in charge or someone within the company working with the authority of the broker in charge will run you through this form again. All right, let's go ahead and start at the top right here. So if you're going to get your form out, we're going to talk about special assessments. This is a continuation from the previous page where we were discussing, hey, buyer, you want to make sure you research these items during your due diligence inspection window. And one would be a special assessment. Are there any in existence now, or are there any that are under consideration that may apply to the buyer once they take possession of the property? The next one is the fuel tank. You want to investigate the situation if we have a fuel tank. Is there one on the property? What type? Who owns the tank? Those sorts of things. Okay, let's skip that note box and go down to letter C, sale of an existing property. Now I'm going to focus on sale of an existing property just for the sake of simplicity and the sake of time. But if we had to lease a property in order to qualify to purchase the home, that would be in effect as well. But here we go. So what it says right here is, and I'm going to read this part to you because it's a pretty big deal. Okay. It says, as noted in paragraph 5B, unless otherwise provided in an addendum, this contract is not conditioned upon the sale of other property owned by buyer. Therefore, if buyer must sell other property in order to qualify for a new loan or to otherwise complete the purchase of the property, buyer should seek to close on buyer's other property prior to the end of the due diligence period, or be reasonably satisfied that closing on buyer's other property will take place prior to the settlement date of this contract. So very good. Let's read D. This is a good one. Okay, watch this. In North Carolina, according to this form, buyer acknowledges and understands that unless the parties agree otherwise, the property is being sold in its current condition. That means that during the due diligence window, let's say it's a 3-week inspection due diligence time frame, shall we say. During that window of time, that 3 weeks, the buyer and the seller might decide to negotiate for repairs, but the seller is under no obligation to do so. So keep that in mind. The property is being sold in its current condition. Another thing to keep in mind regarding repair requests or other items when it comes to due diligence, anything in this sales contract may be renegotiated during that due diligence time frame. In my example, that 3 weeks, everything is kind of up for grabs. Just keep that in mind. All right, very good. And again, the buyer is being advised that they should. And again, the buyer in this paragraph is being advised that they should have set aside plenty of time to allow for repair negotiations to take place if that's what they're leaning toward, and make sure that whatever is agreed to is put in writing and signed by both the buyer and the seller. All right, letter E, buyer's obligation to repair damage. This paragraph says that if the seller's property is harmed during inspections that are brought forth by the buyer, the buyer's agent, inspectors, those sorts of things, that the buyer will be responsible for fixing those items. Letter F says that the seller will not be responsible for anyone harmed on the property during those inspections brought forth by the buyer. Letter G talks about the buyer's right to terminate, that they're saying that during this due diligence window, the buyer can choose to terminate this contract for any reason or no reason at all by delivering written notice to the seller, as long as it's within that due diligence time frame. And then it tells us if the buyer decides to terminate and delivers notice, the contract shall be terminated and the earnest money shall be refunded to the buyer. So once again, if the buyer terminates the contract during their due diligence window, the buyer gets the earnest money back, not the due diligence fee that is surrendered or lost to the seller. All right, let's keep going. Letter H, closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. All right, number next, buyer representations. This is the area where the buyer is going to let the seller know how they're going to purchase the home. Are they going to pay cash or are they going to seek a loan? What type of a loan are they planning on obtaining? Is it going to be a traditional or conventional loan? Is it going to be FHA, VA, USDA? Is it some other type of a loan with maybe it's a private loan of some sort? If the buyer is intending to pay cash, it is advised that the seller obtain something called verification of funds. Okay, let's go. So that's where, and that's all a material fact, because these items will help the seller make a decision as to whether or not they want to work with this particular buyer. In a provision further on within the pages of this 15-page sales contract, offer to purchase and sales contract, it will let us know that there are some inspections or closing costs that the buyer is simply not permitted to pay for. So that's why it's important for the seller to know up front what type of loan. Is it a government loan, FHA, VA, that the buyer is intending to pursue? Because that will again influence the seller's decision as to how they want to move forward. This note box is to let the buyer know that according to this particular offer to purchase and sales contract, standard form 2T, that the contract is not conditioned upon the buyer obtaining a loan. So it's imperative that the buyer, their agent, and the lender really get down to brass tacks and figuring out, can we get this loan completely processed all the way through underwriting, all the way for a final stamp of approval well within that due diligence timeframe. All right, letter B says the buyer either does or does not have other property to sell or lease in order to qualify for the new loan. And if they do, for instance, let's keep it simple and talk about if they have a property to sell, then they need to check the following boxes and let the seller know. Is the property under contract currently? And if not, is it at least on the market? Is it on the market with an agent? Is it about to be on the market with an agent? Or is the potential buyer looking to sell the property themselves as a for sale by owner? You could see how that would be important for a seller to know when they are deciding whether to move forward with this particular offer, this particular buyer or not. Letter C simply says that the buyer is acknowledging or verifying that there are no barriers to them obtaining financing that they know of to purchase the house. Letters D and E talk about the North Carolina specific property disclosures. We've got a residential property and owners association disclosure statement. as well as the mineral oil and gas rights disclosure statement. And here is the area where the buyer is going to let us know whether or not they've received a copy of those disclosures or have they not. The part to pay attention to is have they not, because there are certain consequences if the buyer has not, and this goes for both disclosures, the same rule follows. So let's look at this paragraph. What if the buyer has not received the disclosure? So it says here, if buyer has not received a signed copy of the disclosure, the property disclosure, prior to signing of this offer, that buyer shall have the right to terminate or withdraw this contract without penalty, including a refund of any due diligence fee and the earnest money deposit, prior to whichever of the following events occurs first. Number one, the end of the third calendar day following receipt of the disclosure statement. So let's say that the buyer brings forth an offer to the seller, but they haven't seen the disclosure statement yet. They say, hey, seller, I really want to see the disclosure statement. Please get it to me as fast as you can. Well, for the seller, as fast as you can is 4 days later or some such thing. Well, once the buyer gets that disclosure in their hot little hand, the buyer has 3 calendar days to look it over and contemplate, do I feel confident and I want to move forward with this contract, or do I want to void this contract and get my money back? Okay, that same deadline applies to the mineral oil and gas rights disclosure also. All right, number 2 says the end of the third calendar day following the effective date, meaning the effective date of contract. So same situation. Let's say the buyer brings forth an offer, haven't gotten the disclosure yet. They've asked for it. It's kind of in process. And in the meantime, while we're waiting on it, the buyer and the seller they've negotiated an agreement. And now we have an actual contract. Well, 3 days following the effective date of that contract, the buyer, if they haven't received the disclosure, will have the right to either move forward or back out. All right. And number 3 talks about taking possession essentially of the property. So if the buyer goes ahead and they close on the property, they can't, and they never got the disclosure, they can't come back later after they have closed on the property and say, hey, you know what? I bought a lemon. I never got that disclosure form, either one of them. So I want my money back. That's not going to happen. Okay. So let's continue on. Okay. The note box simply says that if the mineral oil and gas rights have been severed or are about to be severed, the buyer should definitely ask to conference with their closing attorney. All right, buyer obligations. So they're going to be responsible to pay for certain things prior to even purchasing the property. And this is a reminder of what some of those things might be. Now, people, if this is the first time the buyer is seeing this list, then tisk, tisk, tisk. Go ahead and turn this list and make it into part of your 90-minute buyer consultation meeting. Let the buyer know up front what items they're more than likely going to need to pay for in conjunction with the purchase of this property. Letter C, this provision is also in the section about the seller, which simply is saying that the buyer is authorizing the settlement agents who are working to get this property closed and transferred for them to share contact information with each other in order to get the job done. All right, number 7 involves the seller representations. The seller is going to let us know how long have they owned the property. Apparently, some lenders get a little nervous if they think the property is a flip. Maybe the price is inflated or some such thing. So the seller has to let us know that. The seller needs to, if the property was built, this is important, if the property was built prior to 1978, then the seller needs to attach a lead-based paint addendum. And it tells you the form right there, the form that you're going to use. All right. Then letter C lets us know that the seller is responsible for providing the following documents in relation to the homeowners association, if there is one. So the seller is agreeing according to this offer to purchase and contract form 2T to provide those items in the bulleted list to the buyer. All right, let's keep going. And then this area is where the seller is going to fill out the contact information for the homeowners association, verify what the homeowners association dues are, let us know if there are any special assessments that are confirmed or in the works, those sorts of things. Number 8 talks about the seller's obligations. That's a good one. All right, so the seller is going to provide evidence of title, that they're going to provide good title. They're going to provide a payoff statement concerning their current loan if they have one. And if they happen to be a purchaser from out of the country, they may have to provide some additional information there as well. All right, here we go. Let's see if I want to read these little I's to you. I don't think so. I'll just hit them lightly, especially 1 and 2. 3 is pretty rare that you're going to use that. If you are working with a buyer who's from out of the country, be sure to be working hand in hand with your broker in charge, going through that process for sure. So the first little I pretty much says that the seller is going to agree to get certain documents to the closing attorney, which will just help create a nice, smooth, efficient closing. Things like what? Things like if they happen to have, they can put their finger on their title insurance policy, attorney's opinions of title, surveys, covenants, deeds, notes, deeds of trust, leases, easements relating to the property. Now, all of that information, or most of it, can also be found during the title search that the buyer is paying the closing attorney to conduct as well. So if you have trouble getting that information from the seller, again, it will show up in the title search. And then it says the second little I that the seller is going to provide to the closing attorney a payoff statement from their home lender so they can clear that lien from the property. All right, let's go to letter B. Again, is just that same permission to share information, contact information between the parties so we can have a nice, smooth, and efficient closing. All right, letter C, access to the property. Oh, this is a good one. You're going to use this in your real estate career, especially if you are focusing on helping buyers and sellers in an area that's predominantly known as a second home area or has many vacation rentals, those sorts of things. Here's the deal. The seller is to provide reasonable access to the property through the earlier of closing or possession of buyer, including but not limited to the buyer or their agents, representatives, an opportunity to, number 1, conduct the due diligence inspections, number 2, verify the completion of negotiated repairs, and number 3, conduct a final walkthrough. That's all fine and dandy, but it's the last sentence that will get some of your sellers really in a pickle. All right, what does it say? It says seller's obligation includes providing existing utilities operating at whose expense? The seller's expense, including any connections and de-winterizing. You see, often if a seller owns a second home, they leave to go back down to Florida or Texas or wherever it's warm, and they will winterize their home here in the mountains. They'll turn off all the utilities, the plumbing, so on and so forth. Well, if they're selling that home, they need to de-winterize it. They need to turn everything back on, and it's at their cost. Letter D says the seller agrees to remove their property. Letter E is about that lien affidavit. So they've got to sign off that there aren't any potential contractors or anyone out there who could possibly file a lien late in the game against this property. So when Greg and I sold our home in Kenilworth, we had people work on the house to get it gussied up and ready for the market. And we had to track down like 15 contractors to get them to sign that affidavit saying that they would not file a lien against us, that they were paid up and all that kind of good stuff. Letter F says essentially if a lien agent has been designated, and that's for work that's over $30,000 in scope and where you've hired a general contractor, then we need to know about who that lien agent is, so on and so forth. All right, letter G is talking about, well, those are the good one. Okay, let's slow down for G. All right, hold on. Let's slow it down for G. Letter G says the seller is going to provide good title and legal access. Seller shall execute and deliver a general warranty deed. How long is that warranty for? And what does it warrant? Again, it warrants the health of title. Title means ownership, the health of ownership. What we're saying with the general warranty deed is that I will defend the health of this title forever, forever and ever. Forever, Ms. Jackson? Yes, Andre 3 Stacks, forever. You bet. So, and what else? We need that the property is going to, let's see, this general warranty deed is going to be provided in recordable form no later than settlement, and that the seller is going to provide, look at the language from Unit 2, fee simple, marketable, and insurable title. All right, so fee simple, the absolute's been dropped off. Absolute means that you can pass it to your heirs. So fee simple has stayed. Fee simple means no limit to the use, no limit to the time, no limits essentially, as long as it's within the law, no limits. Marketable, insurable title, meaning we can get title insurance on the property. You see, if you purchase a property, an investment property, or property that's kind of being wholesaled, like I was looking at down in Winston-Salem, there were properties out there you could buy for $50,000, $60,000, but they came with a quit claim deed. And a quit claim deed is not insurable by a title company. There could be workarounds, but you want to know that up front. So this is saying that the buyer is going to get a general warranty deed. And there should not be any exception for mechanics liens. The property is going to come free from other liens, encumbrances, defects, including those which would be revealed by a survey of the property. Now, here are the exceptions. The property could come with property taxes, that's your ad valorem, for the current year, although they will be prorated through the date of settlement. The properties could come with utility easements, unviolated covenants, conditions, restrictions that do not materially means big time, materially affect the value of the property. All right, and then we go on to say, in other liens, encumbrances, or defects that the buyer will agree to in writing. Okay, very good. So title insurance protects the new owner. The new owner is going to get a title insurance policy, and that will protect the new owner from title issues moving forward. So in the future, past the closing. So if something comes up, for instance, like 5 years down the road, we discover an unaccounted for heir or some such thing who has an ownership claim to the property, who are you going to call? Not Drake. You're not going to call Drake on the cell phone. You're going to call the title insurance company, and they're going to get on the stick and help fix the situation. Remember, when it comes to title insurance, you will definitely have to pay for a policy that covers the lender's interest, which would be the loan amount. And you could get a second policy that covers the seller, their other portion that's a value that's not part of the loan amount. All right, let's go. Okay. The note boxes are saying, hey, you should get a survey, really, and that just because the buyer doesn't get a survey, doesn't have a title exam done, that the seller is still obligated to deliver good title. The note box tells us that if we're dealing with a short sale, we should use a short sale addendum. All right, letter H is talking about deed, the taxes and fees. This is where you're going to write in who the deed is going to be made out to. So you're going to use the buyer's legal names. And then it says, oh, all the items that the seller customarily pays for. Well, we remember that from our ABC song. Do, 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 do. A, B, C, D, E. C stands for commission. D stands for deed prep. E stands for excise tax, which could be called transfer tax. So be aware of that. Could be called transfer tax. All right, let's go. Letter I is where we're going to write in a number if the seller is agreeing to pay some of the buyer's closing costs. Remember a few paragraphs ago, we had that list of items that the buyer may need to pay for prior to closing or as part of closing. Well, sometimes, depending on the conditions of the market, you may be able to, if you're representing the buyer, negotiate to have the seller cover some of those costs. And those are called seller paid closing costs. And oftentimes, if that were the case, if I could do that, negotiate that for my buyer, I would write in that little blank spot something like up to $3,000, $4,000, $5,000 of prepaid and closing costs. Now, what's interesting here is that we should know or be aware that there could be some fees that the buyer is not allowed to pay if they're getting an FHA or VA loan. And that number, whatever it is, should be put in that line right there for letter I. And here we're told about that again. It's saying the party should review the FHA VA addendum prior to entering an amount in paragraph 8I above. Certain FHA and VA lender and inspection costs cannot be paid by the buyer at settlement, and the amount of these should be included in the blank above. Again, that is why the seller has a right to know, as a material fact, what type of loan the buyer plans to obtain. Letter J, Owners Association fees and charges. This is where the seller has a list. What's the seller responsible for paying for? The other side, when we were talking about the buyer, has a list of items that the buyer may be responsible for paying for if they are buying a home that has a homeowners association fee. So this is a great resource. All right, letter K, payment of special assessments. It says here that the seller shall pay in full at settlement all special assessments that are approved prior to settlement, whether it's payable in a lump sum or in installments. It all has to be cleared and paid up at settlement out of the seller's proceeds. Letter L tells us that late listing penalties means a late tax bill. So if there's a late tax bill, the seller has to remedy that situation and pay it up. Letter M tells us that negotiated repairs need to be done in a good and workman-like fashion, and the buyer has the right to verify that. Letter N tells us if the seller breaches the contract, we should go and look at paragraph 23, my new favorite paragraph, to find out what happens, what are the remedies if the seller were to breach the contract. Number 9, prorations and adjustments. This is where the buyer and the seller get a little information on how certain items are prorated. Things like property taxes, taxes on personal property, rent, if we're selling investment properties, dues when it comes to the homeowners association dues, things like that. Number 10, if there's a home warranty, then we're going to fill this part in. Who's buying the home warranty? How much should it cost? Those sorts of things. All right, y'all. So this concludes this section of going over the offer to purchase standard form 2T. We are going to pick up on page 11 when we have our next segment. So I look forward to seeing you then. And in the meantime, keep studying, keep working hard. Remember, it's us against the test. Who's going to win? All I do is win, 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 no matter what. That's us. We're winning. All right, I'll see you soon.